Any mention?
Please, Lordship. Lordship, I beg to mention item number 41, Lordship. For the petitioner, I have informed to the private respondent, the state respondent also.
Why? Not ready.
Lordship, not prepared to the Lordship.
Okay.
What's place, Lordship?
Item 40. Item 40. I'm free for 2 weeks' time, Your Lordship. I've already informed the respondent.
Let them give a fixed date, because so many times this matter was adjourned.
3 weeks. We'll come up fix date next.
Your Lordship, in that NAPCO CRP, I have filed my bullet points today.
What's CRP?
In NIPCO's CRP judgment, where judgment was reserved, but I was permitted to
bullet points.
Already we have filed.
Yes. Yes, Mr. Chanda.
My lord, actually, Mr. Nitish informed me that he is out of station. Items 27 and 28.
Okay.
No objection, Your Lordship.
Yes.
Mr. Nitish is out of station.
28. 2 weeks, yes.
Your Lordship, beg to mention item 31.
31 also. 31, Mr. Chanda is there.
No, Your Lordship. This is an
Mr.
agreement
Sikon, where's the
matter.
petitioner?
Item 10 on the same day.
That, Mr. Chanda, you speak with your counsel. I will not give fixed dates because it gets adjourned unanimously. Yes. Have you informed the other side?
Your Lordship, it's Sir Sinkan. I don't seem to have.
Then you wait.
Your Lordship. Your Lordship, I also beg to mention item 34 and 35, Your Lordship.
Who you? Mr. Sinkan is here. Number 31. No objection.
No.
Oh, 2 weeks, yes. Would it 1 week, 19 matter? 1 week, yes. Yes, then?
Item 34 and 35, Your Lordship.
Who's for the other side? You informed
Your
them?
Lordship, it's V. Kumar and
35, V. Kumar.
so Arja, and the other one is. So it's both Arja.
Where's Mr. Jha? You wait, let him
Okay,
come.
sir.
Yes.
Your Lordship, I also beg to mention item 39, Your Lordship.
Where's Dr. Mojika gone?
Your Lordship is gone out of station, Your Lordship.
Item 39.
No objection, Your Lordship. No objection.
2 weeks, yes.
Your Lordship, I also beg to mention item 44. Your
What
Lordship, he's on.
Mr. Kumar. Not coming on. 2 weeks, right? Okay.
May it please Your Lordship. Your Lordship, I beg to mention item 36, Your Lordship.
The other side. You're for whom?
And for the respondent 2 and 3, Your Lordship. Leading counsel is S. Jindal.
No objection. Yes.
Much obliged, Lordship.
May it please Your Lordship. Lordship, I beg to mention item number 43, Your Lordship.
Monday morning. It's left for the week. Yes, Mr. Robney, no objection.
Your Lordship, no objection, Your Lordship. Your Lordship, actually, in this matter, we've already complied as per the last order, and notice has been served to respondent 4.
You get a call out. Let me call out. Notice you're preparing respondent number 4.
Respondent number 5, Your Lordship.
Or 4? Why are you asking for time?
Your Lordship, my senior is not well, Your Lordship.
He's still in hospital.
Yes, Your Lordship.
What's happened to him?
Lordship, he got some kind of food poisoning, I think, Your Lordship. I'm not really sure.
Oh. You've given personal service?
Yes, Your Lordship.
Yes, office note indicates that service affidavit has been filed by petitioner bring a report the item of service of notice upon respondent number 4. Stop. Today, MSc non-cala on the paragraph. Please that the matter be adjourned as a senior is indisposed of. And you have your name, sorry?
Biram Seth.
Yes, MS Biram Seth, presently house number 5. Just after 2 weeks is.
Much
you like
obliged, Your Lordship.
Your Lordship, I beg to mention item number 42.
You're for the petitioner?
Yes, Lordship.
You have no objection?
No objection, no.
2 weeks is.
Right.
Arya.
Item number 1.
Please, Your Lordship. Your Lordship, in this matter, the petitioner is aggrieved by the action of the respondents for failure to follow the due process established by law
What due process established by law?
required in disciplinary proceedings, Your Lordship.
What happened here?
Your Lordship, in this matter, the petitioner was initially appointed temporarily as a follower by the office of the Superintendent of Police, Jantia Hills, Jowai. So, Your Lordship, he continued his service. Then after, Your Lordship, he continued till the 3rd of July 2018. Then onwards, Your Lordship, the petitioner...
Till?
The 3rd of July 2018.
And what
From
happened?
the 8th of June 2006, he was appointed. Then afterwards, his post was regularized. After that, he continued his service till the 3rd of July 2018. Then afterwards, Your Lordship, he then received notices dated the 7th of August 2018, the 18th of August 2018, and the 26th of...
Notice regarding what? Show cause?
Not show cause, Your Lordship. These were notices telling him to come back to service because he had been absent.
Oh, you were absent?
I was absent, Your Lordship. So I was directed to come back to service within 3 days of receiving the notice.
To report back for duty?
Your Lordship.
To report back for duty, that's the
report
correct
back
term,
to
yes.
duty.
Then
after that, Your Lordship, after receiving the notice, on the 15th of October 2018, I was served a show cause notice wherein I was supposed to explain, Your Lordship, why I was absent since I had not joined. Then, Your Lordship, I had furnished my show cause reply. Therein, Your Lordship, in my show cause reply, I had explained why I had been absent from duty. The reason being that I had gotten into an accident, Your Lordship, and I had been therefore admitted in the hospital till the 10th of July 2018.
how long in hospital?
Your Lordship, from the 4th.
How, you have period of absence for how many
6
days? How many days were you absent?
Your Lordship, 471 days.
So you were in hospital 6 days and you absent
Your
for
Lordship,
170
I will
days.
get to that, Your Lordship.
Yes.
Your Lordship, so I was served this notice when I was in the hospital.
That's 6 days in hospital.
Yes, Your Lordship. After that, Your Lordship, when I had, then Your Lordship, I furnished my reply. After I furnished my reply, already the disciplinary proceedings had proceeded. And then I had been dismissed on the basis of only my show cause reply. They had not conducted a proper inquiry, so to say. Although an inquiry officer was appointed, he only based his findings based on my show cause reply.
Why did you admit to absence?
In my show cause reply, I did, Your Lordship, but the reason for that was because, Your Lordship, being illiterate, I did not draft my own show cause reply. I had employed the help of a family friend, and the family friend had just
Admitted on your behalf that
admitted
you
on
were
my
unlawfully
behalf.
absent.
Yes, Your Lordship.
Unauthorized absent, okay. Then
after that, Your Lordship, via order dated the 21st of October 2019, I was dismissed by the Office of the Superintendent of Police, North Karo Hills, Rasabelpara. Therein, Your Lordship, the order states that it had relied only on my show cause reply. No evidence was adduced, no witnesses were called for. I was not even given.
No, that's recently admitted. Then what happened after that?
After that, Your Lordship, we moved for an appeal in the office of the director of the Deputy Inspector General of Police. While the appeal was pending, Your Lordship, since I was deriving my salary only from my service, I had moved to the High Court in writ petition number 44 of 2021, wherein, Your Lordship, this Honourable Court was pleased to direct the office of the Deputy Inspector.
What happened? What was the result of your appeal?
that it upheld the order of the
So you're challenging irregularity of the proceedings?
not the clarity or
Not irregularity, not
The
very irregular, yes, of the proceedings. How
illegality
irregular,
of
how
the-
irregular
of the
is it?
proceedings, of the disciplinary proceedings, Your Lordship.
You know that High Court can't go into the facts,
The
only
merits
whether
of the case.
whether it's irregular or correct, that's all.
Yes, Your Lordship.
So
we
what are your
aware.
points on that it was irregular? And they're not given adequate opportunity.
Your Lordship, because as per
You have to
the
start on the basis of natural justice, whether you're given opportunity to show cause or not. You were given,
we were given, Your
correct,
Lordship.
and then after you file
But
show
Your
cause.
Lordship, in the show cause also, as per the law established, my charges should have been defined and definite. They should have explained my
You
charges
belong
to
to
me.
discipline force, then after that, you made those grounds in your appeal.
Your Lordship, we did.
Were
Your
they
Lordship.
addressed by the appellate authority?
Your Lordship, not properly, Your Lordship. They
Not
just
properly.
upheld. They just upheld the impugned
Just
order.
upheld by cryptic order.
Not a cryptic order, Your
Then?
Lordship. They just said that on the basis of my show cause reply. Your Lordship, as per the law established in disciplinary proceedings, I should be given a chance an opportunity to be heard.
You already been heard.
No, Your Lordship, not by
Not
show
heard.
cause. Not heard as in a proper.
Yes, Mr. Gurung. Let us take notice at least. No case otherwise. Yes. Heard MS B Modi. Oh, sorry. D. Yes. Issue notice returnable in 4 weeks. Yes, MS Argur is present on behalf of all the responsible for the notice required. It's just a week for affidavit.
Item number 2.
May I repeat, Lordship? Lordship, here there are 3 petitioners in this case, Lordship. Here they were the Home Guards volunteers, Lordship. They were appointed in 1986, Lordship. And they have been working till this year, Lordship. Then, Lordship, all throughout, they were given the benefit of financial upgradation.
Yes. Benefit of?
That financial upgradation, Lordship. That is benefits of that commission, Lordship. That now the 5th pay commission, they were denied the benefits.
Yes.
That is why we have come to the court and the matter is still pending, Lordship. Because in the writ petition by Lordship, which I am claiming for the benefits of 5th pay commission, Lordship, in that writ petition only the commandant of the Home Guards, the respondent authority, that is 124, that is PSC department, they are saying that unless the revision of pay as per the revision of pay to 2017 is fixed by the commandant, we cannot pay the enhanced salary, Lordship. That is why my Lord has directed the state respondent to seek instruction on that ground, Lordship. Then when the matter was awaiting for instruction, Lordship, then my salary was stopped, Lordship. Then March I approached to the department, they didn't respond, Lordship. Then April I sent my representation claiming for salary through post office, Lordship. Then, Lordship, what they respond, Lordship, that is at page 33, Lordship.
Yes.
Addressed to me, Lordship. This is by the respondent authorities, Lordship. That release of pending salary, Lordship.
Yes.
This is my letter 25 April 2023 with reference to the subject and letter mentioned above. This is to inform you that the salary from the month of January 2013 onwards cannot be paid anymore. This is for favor of your information. Then, Lordship, when the matter was listed, that is petition number 37, Lordship, listed on 22/5/2023, Lordship. That is at page 23, Lordship.
Yes. Yes.
Then I have apprised to this honorable court that we are not giving the salary, we are not getting the salary since January this year, Lordship. Then this honorable court has passed the order. Accordingly, on the following day, I have communicated the order, Lordship, to the department's, Lordship. Then they have issued the impugned order, that is at page 37, Lordship.
37.
Lordship. Last page, Lordship.
Yes.
This is addressed to me, Lordship. This was given in reference to my representation in connection with the order, Lordship, passed by this honorable court. May I read, Lordship?
Yes.
With reference to the subject cited above, I am to inform you that your engagement for duty as Home Guards volunteers with Rural Water Supply Division PSC Joy has been discontinued by the Office of the Chief engineer PSC Meghalaya Shillong by order dated so and so, and the same has been communicated to you on so and so when you visited my chamber seeking for clarification on this matter. The letter from the chief engineer was read and I also physically shown and explained to you in the language you understood. Secondly, since your service has been continued since the end of December 2023 and you have not been engaged with any duties with the PSC from the month of January 2023 onwards, the salary can no longer be paid to you.
What are your terms of engagement here of volunteers?
Lordship, that is that appointment, Lordship, page 30.
What are terms of engagement? I'm not talking about appointment. Terms of engagement of Home Guard volunteers. Suppose it's a requiring department, you go there. Don't require anymore. Is the Home Guard department duty bound to keep you in service?
Yes, Lordship.
What are your terms of engagement?
Because there is...
You are not appointed, but regarding the pay, I think the requiring department will pay your pay, correct? Now requiring department says that we don't need your services anymore. They inform the Home Guard. Now what is the Home Guard, is the commandant or the office of this
that appointment
district Home Guards, like, is it incumbent upon them to keep you in service?
Kindly my appointment, Lordship. Terms and conditions also my appointment, Lordship. That is at page 13. Type copy is next page, Lordship. 13A is type copy.
Yes.
In the interest of public service, the following trained Home Guards volunteers are temporarily appointed as guardsmen with effect from 3/5/1986 in the pay scale of so-and-so PM plus other allowances admissible under the Meghalaya service.
See, that's what it says. The appointments paid temporary and specifically for the guard duty of the PHE stockyard at Minturu, Nipiat campus at Juwai. The service above so-and-so may be terminated any time on 1 month advance notice. Was 1 month advance notice given by the department?
No, Lordship, nothing was given to me.
Nothing was to you. Yes. It will be given to the commandant.
Commandant, that, my lord, what happened exactly? What happened? Because since I have agitated the matter for revision of pay, Lordship, all throughout I have been working 1986 till 2020, Lordship, they have not taken any action. When the matter was, I was agitating for revision of pay, Lordship, they put up some proposal on me that if I withdraw, then they will consider my revision of pay, which I did not consider, Lordship. Then within 10 months, Lordship, within 10 months, I have filed my REIT 2022, Lordship. And within 10 months, they have taken action. I have only 2 years left.
What is the term of engagement of Home Guard volunteers?
Home Guard volunteers, it's
they trained by whom?
It is sent by this respondent number.
They trained by whom?
They are trained by the respondent number, that is commandant respondent number.
They are given training.
There's not training as such because like we also like in the bar, we have got like Home Guard to look after the parking of the vehicle. So with bar association, we engage them. Similarly,
no, that comes, you engage them, you request from the Home Guard. What a term engage if they've been working since 1986. Now what is the, they've been working since 86, correct? That we cannot ignore. Now the thing is that what are terms of engagement and what are the, what rights are they vested with? That's the only thing with regard to pay, salary, so on and so forth.
These are
you take instructions with regard to the earlier order also.
In my appointment below down serial number 5, Lordship, who are going to pay my salary, Lordship. Bill assistant for national action, monthly pay bill of 1 Havildar in charge and the above guardsmen should be prepared and forwarded to the
executive. No, that money is given by the requiring department. Yes.
Here they have mentioned.
S.A. Sheikh Learned Counsel for the petitioner issue notice. Mr. H. Abraham is present. GA is present on behalf of all the respondents. No further. You appear for all or yes, no? Because there'll be different parawise comments coming. The executive engineer, PHE. And 2, 3, and 4 will be different because they'll have their own stand requiring department. And then 1 and 5 the Home Guards.
Same thing on the last occasion, I was appearing for all the respondents. Yes,
no further to go required, yes. Just after 3 weeks for instructions. Yes, it is. For that, it is noted that this is a continuation of WPC number
37, Lordship.
37 is of 2023.
2022, Lordship.
2022, whereby the same petitioners are agitated for fixation of for grant of enhanced pay or upgradation stock. By order dated, when was that? They said, the court said they said that you can last Oh, yes. Order dated 22/5/2023.
22/5, yes, Lordship.
Yes, sir. Report notice of the court that the fee of the petitions had been stopped. For which orders have been passed for the respondents to examine. Stop. Next paragraph, Mr. Chairman to obtain specific instructions on the terms of engagement and as to the entitlements of the writ petitioners. Just after 3 weeks for affidavit.
And the blades of Lordship.
Item number 3.
Here, Lordship, the petitioner's father was working in the office of the respondent as attendant, Lordship. And
which department?
that is
Animal husbandry and veterinary.
Okay.
then while in service 2004, his father died and the petitioner was appointed on compassionate ground, Lordship, on the same year, Lordship. Then, Lordship, his service was not regularized. Generally, Lordship, the compassionate appointments are made on a sanctioned post on a regular basis, Lordship. But the same was not happened in the petitioner case. Then, Lordship, he approached to this honorable court, Lordship. That is at page, Lordship. The court order is page, Lordship, 11, Lordship. Lordship, page 12, Lordship, page, if I read para 6, 7 and 8, Lordship. Para 6, the notification, that is not relevant. Para 7, Lordship.
Yes.
The appointment on compassionate basis is the refresher form normal appointment. The logic and object of such appointment is to save the family of the deceased employee from the financial crisis. The scheme has laudable object of protecting the family from financial hardship. In effect and in principle, the petitioner has been granted the benefits, but unnecessarily with a condition whose condition by itself is diluted because the petitioner has been continuing now for the last more than 14 years. In the stated facts and circumstances, right of the petitioner cannot be allowed to be jeopardized merely on the if said deceit of the respondent authorities.
Yes, heard Mr. S.A. Sheikh, learned counsel petitioner issue notice. So, propose accepting notice. Your name, sorry.
G.N. Ranja.
G.N. Ranja is present, accept G.A. Accept notice on behalf of respondents. This after 3 weeks for affidavit. Yes.
Right.
Hello.
Item number 4.
Yeah, please, Your Lordship. Your Lordship, I humbly pray 2 weeks' time, Your Lordship, to file proper affidavit, Your Lordship.
How many times you prayed?
This is second time, Your Lordship.
Second time you prayed? Okay, 4 and 5. You have 4?
4 and 5, Your Lordship.
What about 1 and 3? 1 to 3.
I will file, Your Lordship. We will file our affidavit.
Today?
No, Your Lordship. 2 weeks' time, Your Lordship.
I'm praying for further 2 weeks' time, Your Lordship, to file it.
Yes, so further 2 weeks time granted the respondent to file affidavit. Just thereafter or something.
5.
What's the point of having a division hearing then? If you're not going to ready to argue it.
Actually, as per the last order, Lordship, they are supposed to clarify the.
My Lord, State has filed an affidavit regarding the disbursement of all the funds, my Lord, for the last 2 years. So, Municipal Board has prayed that they'll take instruction on
Municipal Board
that.
supposed to
Where
clarify
Municipal
this order actually.
Where she was here just now, where did she run away? Where's Mr. D?
I apologize, Your Lordship. Your Lordship, I humbly pray 2 weeks' time, Your Lordship. We are yet to
What
complete
2 weeks' time?
instruction. Your Lordship, we are yet to complete instruction, Your Lordship.
We'll give you on Thursday to complete instructions.
I pray, Your Lordship, please, Your Lordship.
All the sanctioned money has been since from 2001, 2004.
That means there's some scam going on in Baghmara Municipal Board. The court record that the money has been released as per the state affidavit.
We don't have instruction.
Till
Right.
2024. I mean 21 till has been released for this financial year also.
Lordship. It is on record.
Where's the money gone? That's very important. You get instructions.
Yes, Your Lordship.
Last time he said he'll get instructions. MS N. Raji, General Counsel for Response 3 and 4. prays for the
2
1
weeks,
week's time to
2
obtain
weeks, Your Lordship.
instructions.
I am prepared, Your Lordship.
The prayer is allowed. It is expected on the next date, 1 week, that instructions will be available with the concerned respondents. You tell them 1 week, otherwise that they'll have to come personally, where the money can't disappear like that. Employees are being deprived of their salary. State has given the money to them, to your board.
Item number 6.
The matter is regarding condonation of delay of 830 days. And the
844 days you wrote here. 844 days.
830 days. But I calculated yesterday, I calculated again, total happens to be from the date of the order, excluding the holiday granted by the Supreme Court, it happens to be 862 days. And actually the date was not put by me, it was put by the registry. They used to ask us to keep this blank because sometimes mistakes are there, we have to keep correcting every day. So it's actually once 862, 32 days have been excluded because of holidays or something maybe. Only explanation I have is that I didn't know about the impugned order. I came to know only after getting the certified copies from the court due to lack of communication with the counsel. That is the only ground I have.
See, at least one thing, Mr. Bora, like you're a seasoned counsel. Suppose, if you're seeking condemnation due to, not being informed about the dismissal of, of your suit or certain order being passed, from the date of your knowledge, at least to the date of coming to the court, that should be explained day by day. Whether he had a stomach ailment and couldn't go and meet a lawyer that day, or whether he met him at 7:30 in the evening and gave the papers, and when did he drop the papers and call you again for consultation, and when did he prefer the application to the court, how long it took for them to register, that should be here if you want to satisfy the court regarding ignorance about dismissal orders. Not that it was dismissed and one fine day I woke up and I went to the court and tried to get restored 84 days.
The copy was
I'm sorry I have to say this, but that is the practice which is expected. That if you are making a statement that for 800 days I didn't know that the matter was dismissed, from the date of knowledge till now you have to explain day by day till the time was filed and it's come before court.
Yes.
Where is it?
My lord, in the annexure 2 of the main petition actually.
No, annexure 2. I'm going for a condemnation application. Which paragraph you said that on the date he came to know about the dismissal of the case on that date at that time. Then in the evening I eventually went and to show that you have a due diligence or diligence with regard to pursuing your matter. Otherwise, condemnation is not given just as as a freebie. If you're not, then what? When did the petition come to know? Which date?
I may be allowed to withdraw and file it again, elaborating this from the date of receipt of the certified copy, my lord.
When did he come to knowledge? When did he apply for a copy? I'm not talking about a date of receipt for a copy.
July
when did he come to know about the dismissal?
Came to know.
When did he apply for a copy? Yes. When did he receive the third copy? When did he go to the lawyer? How long did the lawyer take to prepare the restoration application?
I'll clarify that with an affidavit, my lord. That date
yes,
by date.
Mr. Gautam. Not that I'm arguing your case for you, but just for general information. That is because condemnation are coming without the explanation. And some cases which are really well worthy of being adjudicated are being dismissed because there's no explanation for the delay.
My lord, there are two things here. Number one, the computation of days is wrong, my lord. He has taken recourse to the limitation holiday in the suo motu proceedings by the Honorable Supreme Court. That in my respectful submission will apply only in cases where limitation would have expired during that period, or limitation would have started during that period. In his case, limitation expired long back. Now, secondly, he has filed a petition under 227. Now, in my respectful submission,
no limitation, no limitation.
No limitation applies.
Yes.
The only thing is that he is required to be. There should not be any delay or latches attributable to him.
Explanation of the delay. That is.
Now, the important thing is that what he has done is what the petitioner seeks from this court is restoration of a injunction application which was dismissed about 5 years back. Now, this application was lying in the court for almost 6 years. So, well, admittedly, a petition under Order 39, Rule 1, in essence, must have the element of urgency. The fact that he did not take any steps for 6 years clearly shows that there is no urgency in his case. So, in any view of the matter, his application.
From 27th July 2000.
So it was dismissed. He never pursued injunction application there.
No, I did not know about anything happening in the court for those years.
6 years.
You are a client. It's your property.
Yes,
you think the lawyer will be bothered about the property? You don't come.
Yes.
Then
This year, the lawyer gave me NOC. Before that, I had no contact with the council. That's why I didn't know about it. I came to know
Why
only
have
after
contact with
getting the
council?
certified copies.
why do you have contact with the council? If you're, it's a
It's
order
happened that
39.
last year, the respondent one, her sons, they came to the suit premises to evacuate the tenants there. Then a police case was filed. The police had called them.
Oh,
and
that
they
is
were
why.
left
That
on-
is why. Then you got interested in the case
Thereafter,
again. Yes.
then only the party
That
came
is
to-
why. That is why. Now
to
the
me,
real
actually.
reason has come out. You never interested while everything's
had
fine.
didn't get any information from the previous council, so they came to me. That's what. That is the only explanation.
Sir, council, sorry.
Moreover, my lord, this condemnation petition does not contain. They have submitted through an attorney, power of attorney. That power is not enclosed.
This has been filed to someone else.
Yes. It's in the main case. Attorney has been filed. Now they'll ask me to file wakalatnama also with the condemnation petition. Then I have filed wakalatnama in the main case.
And also the impinging judgment has not been annexed with a condemnation petition.
Well, in the main suit also there have been two attorneys, my lord. Without revoking the earlier power of attorney, subsequent power of attorney was filed and a subsequent representative has come.
I'm sorry, Mr. Bora. Your client doesn't deserve, the time of the court. The application as made under Section 5 Limitation Act 1963, brief coordination of 843 days as per submissions of the counsel for the petitioner. Stop. Though an application of Section 5 in the 227 application would not lie, however, reasonable explanation is to be offered with regard to the delay that has been caused in coming before the court and seeking appropriate orders. Next paragraph. Vehement objections have been raised by the counsels for the opposite parties with regard to the maintainability of the conviction application, the applicability of the Supreme Court order with regard to limitation, and also on the conduct of the petitioner. Stop. Mr. Bora submits that the entire delay has been caused due to the ignorance of the petitioner as to the dismissal of the Order 9 Rule 1 and 2 application before the trial court. Stop. Next paragraph. Trial court and as such, the petitioner having recourse has filed instant application before this court. Approval of the conviction application, however, does not reflect any urgency or in which manner the petitioner pursued the case. Stop. As no sufficient grounds have been made out for condoning any delay, if any delay. The case is dismissed on merits as no reasonable justification has been given for the long period of incoming before this court by the connected 227 application. Then deserve it, Mr. Bora.
Obliged.
Item 7.
May it please, Lordship.
Yes.
Lordship, as per last order, Counsel Mr. P. Ubin was supposed to appear before the National Court, but Lordship, he is not able to come today due to his some personal works. He has to be out of station.
You are G. Ubin?
Yes, Lordship.
His own brother?
Yes, Lordship.
Okay.
So, Lordship, I humbly pray that if this matter could come up tomorrow.
Your Lordship, Mr. Shulai will be handling the matter and he'll be on leave from tomorrow, Your Lordship. So the matter can
Till
come
when?
up next week. This entire week, Your Lordship, he'll be
Just
on
after
leave.
1 week, due to absence of Mr. P. Ubin.
Deeply obliged.
Obliged, Your Lordship.
8.
Your Lordship, we have received both the affidavits. However, we will not be filing any rejoinder from our end. So, if this matter can be listed for hearing, Your Lordship.
Listed for preliminary hearing in case we need to issue notice of contempt. Has contempt been made out?
Not exactly, my lord. Here they failed to show whether the disobedience is willful or not. We all have been saying, my lord, through our repetition, through our affidavit, that the default is not willful. They are required to prima facie show that
Let's have
disobedience is willful.
This is matter for list for orders when? List for orders and we'll hear on that day. When?
Next week, Your Lordship. Monday.
After 1 week, yes. Affidavits have since been filed by the respondents. MS Truth House submits that no rejoinder will be necessary. This is a matter for orders after 1 week.
9.
May I please, Your Lordship? Your Lordship, I'm praying for 2 more weeks to file my reply
Have you
opposing
made
the
application? You give it to her.
Your Lordship, actually, I'll be filing adjournment petition, Your Lordship, because
It's an application for adjournment on behalf of the election petitioner for the reason was stated therein. So, accordingly, this is matter after 2 weeks. The petitioner is also permitted to file the objection to the Order 7 rule application. In the meantime, yes.
10.
Lord, affidavit is yet to be filed, my lord, in this
Your
matter.
Lordship, just bring a week's time, Your Lordship.
Yes.
Okay, similar matter fixed on 10th of August, my lord.
For hearing.
In the meantime,
It's fixed for what on 10th? Fixed for?
fixed for hearing, my lord.
Is it correct?
Your Lordship, I'll have to cross-check.
Okay, this matter on 10th of August. Like, if it be filed by the respondents in the meanwhile. Yes.
Deeply obliged.
11.
Please, Lordship. Lordship, I have filed my rejoinder, Lordship. This can go for hearing, Lordship.
We can dispose of what's the matter about, Mr.
Lordship, I have not received the copy of the affidavit.
We
According
have
to him, he has
served
served in the office.
We have
but
served in the office.
I'll collect it from
Someone
there.
submits that the rejoinder has been filed. Accordingly, this is matter for hearing.
Lordship.
No urgency.
Not urgency.
12.
some more time and for respondent of 4 to 8.
What's the matter about? Appointment to?
Appointment of assistant teacher, professor in Shillong College, Your Lordship. So, because petitioner
Now,
already appointed, but he has challenged the appointment because he was not appointed.
now what about you're appealing for whom?
I am appealing to state respondent.
You have filed the affidavit, right? Yes. What about number? That is respondent number.
4 to 8.
Why are you not filing your affidavit?
We will be filing. We need to let some.
What about number 10?
Your Lordship won't be filing.
Number 11? Yes. Will you have you filed the affidavit? You're not filing.
not required because it's a dispute between, it's an appointment matter. We are merely pro forma respondents.
Okay. Yes, Ms. MS Adatta, we have response 4 to 8 days for, and it's allowed for a 2 weeks time to file affidavit. MS Esrum Town, we have number 10, and MP Agarwal 11 submits that no affidavit be forthcoming from their side. None appears for respondent number 9. Number 9 is whom?
If a private respondent.
Private
We
respondent.
have challenged the appointment of
His
respondent
appointment.
number 9.
Is there-
Yes, Your Lordship.
Number 9 who is a...
May I please, Your Lordship?
No appearance been made on. However, no appearance is made on behalf of respondent number 9. This matter will
Yes,
be
Your
for
Lordship.
affidavit and for appearance.
May I please, Your Lordship? I may be allowed to take steps by way of custody service on respondent
number
number
nine?
9. Yes, Your Lordship.
Okay, now look at number 9. Untuk MS Salam please be allowed to effect custody service on respondent 9 within 3 days. This thereafter on after this accordingly on so and so.
13.
These matters affidavit are yet to be filed by the state, my lord. There are a number of cases, my lord. 13 to
Concerns
23,
what,
my lord.
Mr. Prasad?
Regularization.
My lord,
Your Lordship.
regularization.
Regularization.
Which department?
Lady supervisor. To the post of lady supervisor.
Okay. Why? When was this filed?
On 28 April, Your Lordship.
A lot of time has gone.
My lord, April, 3 months have gone, my lord, definitely. But there are a number of cases, my lord. Actually, we have not received Parawai's comment in all the cases.
They are not alike, all of them?
They are like
They are more or less for them, my lord. We are waiting if there is any. Well, it depends. Maybe, my lord, they are otherwise in service, my lord. So,
This is social welfare.
Yes, Your Lordship.
With Mr. B. Bhattacharya, we have the state respondents under AG, we have to pre-respond around further 2 weeks' time to file affidavits. This thereafter and so and so.
all right. 30 to 23.
24.
Okay, this is again that compassionate appointment matter, my lord.
Yes.
Here, my lord, we had informed the clients about lordship's impression on the matter, my lord. They had actually, through me, my lord, beseech upon you to take up this matter, my lord, since the lordship's jurisdiction to take up this matter is not like exclusively barred, my lord.
See, Mr. Thapa becomes very difficult. CAT is functioning. See, CAT is functioning and we cannot, like it's not only self-restraint, but it's also like the discipline. How will we pass orders in this matter when you have to go to the San Absolute Tribunal?
Well, the lordship's power under 226 comes.
That we cannot go there. Then any other case where you have
here-
a compassionate angle,
here-
that means the court will have to exercise power. When you should go to CAT.
Right. No, my lord, here what has happened is, in fact, we were informed that there are circuit bench of CAT in Shillong also. To that extent, my lord, we are trying to find out whether it is actually correct
It
or
comes
not.
sometimes. You get some legal aid done in
This
CAT
matters
court
could be-
also. What is there?
If this, we are just trying to find out, my lord, if that matter could be, my lord, filed and taken up in Shillong.
No, it's not. Doesn't work that way. You file a in the principal seat itself.
Correct.
Then when they come here, they bring the file which dealing with Shillong cases.
No, my
and they
lord,
sit here.
that is why, my lord, we are trying to communicate with the CAT.
You get a legal aid lawyer in Guwahati. What is the problem?
It's again, my lord, I am informed that they have been served with the vacation notice also.
Whatever it is, it's difficult. I mean, the court will not take up.
I would pray, my lord, this matter could be fixed on Wednesday, my lord.
Okay, let's come Wednesday, but then that the mind of the court.
I'll
There'll
just,
be
try to convince them.
umpteen matters where then they will say, oh, you've exercised jurisdiction in that case, in this similar case.
Correct.
We can't create a precedent. It's
We'll have
goes
it
to
on
CAT,
Monday,
goes to
my lord.
CAT.
I'll just try to explain.
Otherwise, by next date, we won't entertain it anymore. Yes.
25.
Yes, on Wednesday, as prayed for by the counsel for the petitioner, to allow him to obtain final instructions. Yes.
May I please, Your Lordship? Your Lordship, I prayed for 3 weeks' time, Your Lordship. File affidavit.
You are appealing for which respondent?
Respondent number 2, Your Lordship.
Number 2 is whom?
Mohammed Habib, Your Lordship. Mohammed Habib.
Number?
Mohammed Habib, respondent number 2.
Is for condemnation. What is the matter about?
My lord, yeah, my lord, we have prayed for allowing us to deposit the rent, my lord, areas of rent.
Oh,
that matter.
Why are you asking for
They are
that?
the landlord and
Okay.
respondent number 1.
Okay. How much time?
3 weeks, Your Lordship.
2 weeks for the time granted respondent number
2.
2 to file affidavit. Just thereafter.
26.
Yes, Mr.
Please, Your Lordship, respondent number 4 and 6 are yet to appear.
In the meantime, I'll file one small affidavit bringing on record some document.
No need, we'll list it next week. No need, what document you to file now? On the prayer of the petitioner submits that on behalf of respondents number what?
4 and 6.
4 and 6, no affidavit forthcoming. This is a matter on, we'll give you a good date. This is a matter on 3rd of August. By the time your job will be done, Mr. Khan.
Hearing 29.
My lord, in the last occasion, Lordship has heard the matter. This with regard to taking over of the school management by the respondents,
Yeah.
my lord. My argument was that, my lord, it was wrongly taken over lower and upper primary school. After hearing Lordship indicated that as to how to move forward, petitioner is a retired servant now. I've spoken to the parties. The parties are agreeable since the time for the board of managing committees are over. Your Lordship direct the government to conduct a meeting for electing the new managing committee for both primary and upper primary. Teachers and parents representatives are there. They can decide it.
Yes, you take instructions.
My lord, I'll take instruction, my lord.
Yes, Mr. H.L. Chareso, senior counsel assisted by so-and-so, clearly submits that the dispute concerning the instant petition can be resolved amicably by directing for the reconstitution of the managing committee of the concerned school, both at the upper primary and the lower primary. Stop. This he submits because of the fact that the petitioner also has since retired, and for the benefit of the students.
Yes.
And for benefit of the students, it would be she has also since retired. Stop. Next paragraph, Ms.R. Kohli.
My lord, with Mr. Abraham, my lord, 29 and 30 are analogous matter.
Mr. R. Kohli and Mr. H. Abraham apply in connected matters, but also Mr. B. Kriam have no objection to the suggestion of the senior counsel and petitioner, but they have prayed for 2 weeks' time to obtain instructions.
I will take instruction.
This thereafter.
But let my friend also take instruction.
Yes, they have to take instruction. Otherwise, close it. It's for the benefit of the students.
Yes.
32.
See, the previous date, my lord, my learned senior has produced some documents, lordship. So today I had a contact with my client till date, lordship. Till
You not caught up with your client?
No, I didn't get my benefits, lordship.
He's not got his benefits?
No, lordship.
You consulted your client?
Pardon?
Did you consult your client?
No, I have a contact. Today I contacted my client, lordship.
What do you mean? You're supposed to obtain detailed instructions. Not a question over the phone that you've not got. See, you see the last order.
Yes, lordship.
5/7/23, pursuant to the order dated 25/5/2023, repair respondents have since processed the leave term benefits of the petitioner. Mr. A. Kharwanlang, with Mr. A. Kharwanlang. Yes, produce some communication substantiate this fact. What about discrepancy in dates? Where's Mr. Kharwanlang?
Lordship, I am there, Your Lordship. It appears, Your Lordship, that everything has been done, Your Lordship. It will take some time, Your Lordship, because it appears that everything has been done, Your Lordship.
Appearance and then the, concrete materials are totally different.
And then, Lordship, even the PP also has been forwarded by the accountant office of the accountant general.
Why did you get detailed instruction from your client?
Here, Lordship, only the thing is that we are waiting for the pension, Lordship. So far as pension is concerned, Lordship, that I am not getting the pension, Lordship. They are supposed to give my pension, Lordship, as per the letters they have shown.
See, now the letter they've given you, has any steps been taken towards settlement of your terminal benefits or not?
Not issue, Lordship.
Not yet?
Not yet, Lordship.
0 steps?
Yes, Lordship. Only the communication letter, Lordship. Apart from this communication
there
letter,
is the communication from the Office of the Accountant General to the Treasury Officer Sora for paying PPO for paying of pension.
It's under process, Your Lordship.
It will take time.
There's a procedure also for the petitioner to go and appear in the Treasury Office.
it is not the process, because earlier I got the provisional pension for 6 months, Lordship. It is not that they are initiating that fresh, Lordship. It is already been processed. Because of pendency of the case, my benefit has been withheld, Lordship. It is not a case that they are...
No, sometimes because the pendency of the case, it creates complications.
True, Lordship.
Because I think...
What rules matter? We close it?
No, Lordship, because I have prayer for interest, Lordship. Because as per the order, Lordship,
even he will be getting an amount of 3,84,000 also, Lord.
23, my Lord. My Lord have also only the issue of interest is left, Lordship.
That already sanctioned.
Once what I am...
With interest?
No, Lordship.
No, Your Lordship.
This is only for my... They have calculated my gratuity and leave encashment.
Okay, this is a matter of 3 weeks, Lordship, to enable the parties to file instructions. Otherwise, we won't keep these matters pending, pension matters for nothing.
33.
I'll apply, Your Lordship.
Ready, both of you? Start.
Your Lordship, conducting counsel is engaging in another next to courtroom 3, Your Lordship.
We'll wait for him. He'll come, yes, after some time.
Lordship.
What's the matter? Nokma matter?
No, Lordship. Non-payment.
This is? Non-payment gratuity?
Yes, sir.
We'll pass for time being. Yes.
34.
Mr. Char is seeking time, but it's not adjourned because you are not present. After?
2 weeks, Your Lordship.
No problem? No urgency? No. Yes, this is matter after 2 weeks due to the absence of the Dr. M. Bozikal and the DSGI.
35.
35 also?
37.
Your Lordship is still in next to courtroom 3, Your Lordship.
You ready?
Yes, Lordship.
You ready? Yes. Very good. What's the matter about?
Regarding the settlement of fishery, Lordship.
Okay, are you arguing the matter?
What's the call we are arguing about?
He's here. Let him come. It's also about time being. Take up the other matter first.
38.
Your Lordship, I've consulted with my client regarding this. It was last week, so they have agreed. Subject to that time frame of, I've just spoken to him, so they would be able to.
Within 1 month from the date of receipt of the application.
The mode of sending the application by an email, which we have done earlier also, which they have replied to that also.
Okay.
It can be both ways, by an email or also physically.
Yeah, you send a physical copy also.
Okay, I'll do that.
I'll take down. The brief facts of the case is that the petitioner, whose husband was a qualified surveyor, and loss assessor, LOSS assessor, ASSE was an associate member of respondent number 3. That is respondent number 3. That is the Indian Institute of Insurance Surveyor and Loss Assessors, with its offices at Hyderabad. So, it has been contended on behalf of the petitioner that as the deceased husband of the petitioner had availed of the benevolent scheme provided by the said respondent number 3, the nominee on his death was entitled to receive a compensation of rupees 5 lakhs only. Stop. However, it appears on the death of her husband, in spite of the petitioner raising a claim against the IBF scheme, the same was rejected with the reason that the subscriptions were not up to date. Something like that, right?
It's due from him.
Was due. Next paragraph. Our subscription for the financial year 2020 to 2021 are still due. Next paragraph. When the matter was brought before this court by way of the instant application, objections had been raised as to maintainability and also to jurisdiction. Now, the objections were primarily on the ground that, yes, Mr. Nopur, that the respondent number 3,
the petitioner has an alternative remedy.
That the petitioner had an alternative remedy, and that any suit or proceeding was to be instituted at the place of
at the registered office
within the jurisdiction of the courts where the registered office is situated from. Next paragraph. In the course of hearing on the last occasion, however, the respondent number 3 on instructions, correct? Instructions has conceded to consider the claim of the writ petitioner, provided appropriate application is made under, what is the relevant rule?
Rule 12.
Appropriate application made under Rule 12 of the
rules and regulations. ISSLA benevolent fund.
ISLA benevolent fund. Give me the full nomenclature. What's it, Mr. Mapan? You already filed it under 12, he said.
Actually, we did not file. We just sent an email just to intimate them. And
what is the scheme called?
Page
of your?
3 of the writ petition.
Writ petition. What is page 3 writ petition? It's called the IISLA Benevolent Fund Rules and Regulations.
course of hearing on the last occasion, however, the respondent with 3 on instructions has considered to consider the scheme of the petitioner provided appropriate applications made under Rule 12 of the
IISLA, Benefit Fund Rules and Regulations.
The Rule 12 of the.
The Rule 12 of the so yes. In this backdrop, therefore, Mr. Dinner Counsel with petitioner Mr. So-and-so submits that such application will be filed by the petitioner within the period of, from the order?
1 week.
In a period of 1 week from the date of this order.
And 1 month.
No, that is next paragraph. Due to submissions of the counsels for the parties, in view of the facts, circumstances of the case, and view of submissions of the non-counsel of the parties, this writ petition is disposed of with the direction that the writ petitioner shall prefer an appropriate application under Rule 12 of the so-and-so, and on acknowledgement of receipt thereof, both by email and by registered AD, and an acknowledgement of dispute thereof, respondent number 3 is to dispose of the same within 4 weeks thereafter.
4 weeks.
Yes. With the above noted directions, the matter stands closed and disposed of.
45.
Your Lordship, as per the last order, Your Lordship, steps have been taken.
You file affidavit of service also. Yes, also indicates that affidavit of service has been filed with petitioner, indicating factum of service on respondent number 5, but none appears in the behalf 3. Who's number 5?
The Dorbashnong Nongra.
In the interest of justice, next time, however, this matter for 2 weeks to await their appearance. This also.
46.
Yes, you start. I won't interrupt.
My Lord, earlier, the senior Kenching led the argument.
Where was Kenching today?
She informed me that she will not come today. So, I may
proceed. The rest on your shoulders now.
I may proceed, Your Lordship.
Yes. Why not?
My Lord, regarding this issue, according to me, my Lord, the jurisdiction with regard to Ripoy district is settled by the division bench judgment. But with regard to jurisdiction, other than the Ripoy districts, my Lord, the division bench.
Well, the judgment.
I don't know. I have submitted in the last occasion also. It must be on record. Must be on record.
Yes.
The case, that Kumarjan case. I've compiled and given a derivation.
Where's the compilation?
We have extra copy.
No compilation?
Only downloaded copy with you. DHE has.
Now, what you see, first point is.
My Lord, these para 34 to 38 of this judgment would be very clear that the.
No, first submission is that it will not apply to.
Yes.
It applies to Ripoy.
It applies to Ripoy only. Because there was a notification. That was what the learned division bench held. But with regard to other districts, there was no notification conferring power to the ADCs or session. Now, Lordship, may we read together para, my Lord, 34 to 38.
Yes.
It will be very clear. May I start with 34? Then thereafter I will show the notification upon which the division bench rendered the judgments. My Lord, it says, my Lord, however, in view of the second paragraphs in both the notifications of December 10, 2015 and May 3, 2018, The earlier notifications pertaining to trial of serious crimes within Riphoi district stands superseded, and the power previously conferred to the district council courts or particular officers can no longer be exercised to the extent that it has been superseded. The other unremarkable point made on behalf of the appellant pertains to the indication of the source of authority in the several notifications referred to herein. Well, in the ideal situation, the statute and provision conferring the power and extent of such authority may be quoted while issuing notifications conferring jurisdiction. The fact that the power to publish a notification is not indicated or an erroneous provision is quoted would make no difference as long as the power to confer jurisdiction is there. There is no doubt that the power under paragraph 51 of the schedule to the Constitution of India permitted all the notifications referred to herein above to be issued irrespective of whether such authority was indicated in the particular notification or the power invoked for such purpose was erroneously traced to some other rule or other order. Whether under rules of 37 or under the subsequent rules or finally the Constitution, it is undeniable that it is the governor who has authority to confer jurisdiction on courts and officers for trying serious criminal matters. As such, the faulty nomenclature, the inappropriate invocation of the power, or the complete failure to indicate the authority for such purpose, if at all, piles into insignificance, as it is evident that the governor possesses the requisite authority to direct the issuance of the relevant notifications. Finally, there is an imaginary cause that the appellant finds to be lurking in the second paragraph of the recent notification issued to make the Code of 73 applicable to all criminal matters in the state. The appellant apprehends that such second paragraph is a disingenuous provision mischievously included in the relevant notification to regularize the trial and adjudication of all criminal matters that may have been conducted without jurisdiction as canvassed by the appellant in the present case. Since no irregularity, far less any illegality, has been found in the conduct of criminal trials, as in the present case, the validation of the trial conducted in this case need not be on the crutches of the second paragraph in the relevant notification of September 2022. Though it is not necessary to look into the basis for including the second paragraph in the said notification, prima facie it appears to be by way of abundant caution. At any rate, the justification or efficacy of the relevant paragraph may be more appropriately assessed when it is pressed into service. In the present context, it is wholly immaterial. For the reasons aforesaid, there is no merit in the objection raised by the appellant as to the jurisdiction of the trial court in this case to conduct the criminal trial, adjudicate the matter, and pronounce its judgment and order thereon. In terms of the notification of May 3, 2018, the office of the district and session judge, as specified in the Meghalaya Judicial Service and such, was vested with the power to the present case as it involved a death sentence, and the appellant's challenge to such authority is in vain. The merits of the case, so second part later on, merits of the case. Now what the learned the division bench held is that, my lord, at the time of taking up consideration of this criminal appeal, the respondents produced that 2018 notification, apart from my compilation of series of notifications, and take the plea that since they admit one thing, they also admitted that yes, governor has already invoked para 51, conferring power upon the officer of district council to try serious cases. But only exception, they say, only exception since there is a specific notification in the Riphoi district. Therefore, Riphoi district session judge has the power to try my case. So that was the contention. My reply was that, my lord, since governor has exercised the power, once he exercised, that conformity confines to all the territory of the autonomous district. Therefore, governor cannot bifurcate the territoriality of the district council and confer power to one officer or one court. If he wants, he has the power to revoke. We admit that he has the power to confer it, he has the power to revoke it. But once he has conferred it, he has to revoke. Because the Sixth Schedule do not contemplate bifurcation of the territoriality of the autonomous council. That was the contention. On that line, my lord, argument took place and this judgment was delivered. Now I may place these two notification, 2015 and 2018 notification. Right. Yes, madam. Previous notifications are there prior to 2011 also. May I start from 2011 only? Right. So 2011, my lord, this was the conferment upon Mr. my lord Stelwell Assembly, judicial officer, our officer of the district council. That was continued the next page also 2015. This was placed before the learned division bench also, and they also did not dispute. Respondent state also admitted yes, their conferment is there. Now 2015, my lord, which I have flag mark. May we read together the content, my lord. Here they try to lay the foundation from here, my lord. In exercise of the powers conferred under Rule I1, capital A of the Rules for Administrative Justice and Police in the Khasi and Chendi Hills, 1937, and further under subsection 1 of section 2 of the Meghalaya Autonomous District Administrative Justice Act, Sansad 1960, as adapted and amended by the Meghalaya, read with paragraph 5, my lord, is important, paragraph 5 of the 6th schedule of the Constitution of India. The Governor of Meghalaya, with the approval of the High Court of Meghalaya, is pleased to appoint Srimati such and such in charge District and Session Judge, Ripoy District, as the Additional Deputy Commissioner, Ripoy District, for the trial of all offences punishable with death, imprisonment for life, or imprisonment for a term of not less than 5 years, under the Indian Penal Code or under any other law for the time being applicable to the district, and also to hear all civil and criminal revisions, appeal, etc. from the decisions of the Assistant Deputy Commissioner within the said district, and the Governor is further pleased to direct that such district and session judge as Additional Deputy Commissioner shall, for the purpose of proceed, exercise all the judicial powers of the Deputy Commissioner within the said district. This supersedes all earlier notifications issued under the aforesaid provisions within the Ripoy district. Now, this is appreciated by the division bench. The contention before the division bench, my argument is not revisiting that one, but I'm trying to highlight under what circumstances division bench has delivered this judgment, and try to make out a case from my side that division bench judgment is not applicable to different districts. Now, my argument was there. This conferment was the appointment here was, my lord, appointing the person. My lord,
it's persona designata.
Persona designata. Persona designata. When persona designata you confer, she was holding the post of district and session judge, Ripoy. Therefore, at that time, my lord, my argument was district and session judge was not there, since CRPC was not applicable. Because the section 9 of the CRPC clearly says that, my lord, first session to district would be created, session division would be created, and appointment of session would come. When the session division is not there, my lord, session judge cannot come. Therefore, appointment comes in that way. But in reality, my lord, my submission was that she was discharging the power under the 1937 rules, not the 60. And she was trying for the offences, serious offences, where both the parties are either one is tribal or non-tribal, or even both are tribals but coming from different districts. So she was trying there. She was for that purpose, this appointment was given to her. Therefore, para 5 quoted by the governor was a misnomer. Because the para 5, when we read, my lord, there is no question of hearing revision or appeal. Para 5 confer the power of the officer, and that officer will exercise the first jurisdiction. So my humble submission was that para 5 quoted by the governor was misnomer. The substance of this notification is conferring the person designated to act as the ADC under 37 rules to trial cases.
Okay.
Yes. So all the other serious matters where both the parties are tribal coming from the same district, it is taken care of by the district council officers. That was the argument. Now, another notification, my lord. The next page, my lord, 2017 notification is there, conferring to Balarisha Ledma, 2017.
Yes.
On that basis, on the basis of this notification, so long bail judgment, Supreme Court also rendered judgment that once governor has conferred the power, district council has the power to take up the cases. My lord. Now I will come to the second flag where the respondent state was heavily lying before the learned division bench. May I read, my lord?
Yes.
It says, my lord, in exercise of power confer upon 1I of the rules for administrative justice and police in the Khasi and Jente Hills 937 and further under subsection 1 of section 2 of the Meghalaya Autonomous District Administration of Justice Act 1960 as adapted and amended by the Meghalaya, read with para 5 of the 6th schedule of the Constitution of India, is pleased to confer the district and session judge, Ripoy District, with powers of additional deputy commissioner, Ripoy District, for the trial of all offences punishable with death imprisonment for a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the district, and also to bear all civil and criminal revision, appeal, etc. from the decision of the assistant deputy commissioners within the said district. And the governor is further pleased to direct that such district and session judge as additional deputy commissioner shall, for the purpose of said, exercise all the judicial powers of the deputy commissioner within the said district with effect from the date of joining. This supersedes all earlier notification issued to this effect under the aforesaid provision within the Ripoy district. My lord, the last, but this supersedes. Learned division bench has quoted this one. Now, my argument was that at that time also, my lord, this earlier designation was also a designator. Now, since conferment is given to now to the session division, so the earlier notification was, my lord, superseded. It was not the, my lord, superseding the conferment given to the district council officers. It remains the same. That was my argument. That was my argument.
Yes.
Therefore, my lord, this 2018 notification did not, my lord, take away the jurisdiction of the district council court. Because they received conferment and their trial is going on, even coming from the Ripoy districts and other districts.
Yes.
But the learned division bench said no, with regard to the Ripoy districts, conferment is there. So governor has the power to confer it. He has the power to give it to another officers.
Yes.
So he has given to another officers. And this has superseded earlier one. So district session judge has the power. My second argument was that 2018 also, session division was not there. Session division only came into being, my lord, in 2022 notification after extension of the 73 code. But in the wisdom of the learned division bench, held that no, my challenge to the jurisdiction cannot be entertained. Session judge in Ripoy acted as a ADC, has the power to try the case and render the judgment. Failed to interfere my lord argument. Therefore, this judgment, my lord, the judgment delivered by the learned division bench is purely confined or render in the context of these two notifications. It doesn't talk about the matter of jurisdiction with regard to other tribal areas. Since conforming is there upon the...
What about, were there similar notifications for other districts or not?
It is not there. So far as my effort is concerned, okay. It is not there, my lord. And it is not the case of the state also, that similar conforming is there in other Nongstoin or other East Khasi. It is not there. Absolutely it is not there. Only this one. So it is a jerk reaction from this case. The government has issued that extension of the CRPC and CPC in all the places also. But that is different issue. But now therefore this judgment is purely confined
to Ripoy
only. Therefore any cases, my lord, where both the parties are both the tribals, so long as conferment given to district council officers are there, they have to try. They have the jurisdiction to try it. And in my case, Yokumar case is purely arising from the East Khasi. So my humble submission is, my lord, the transfer application which we have placed before lordship consideration may be considered for transfer to the appropriate.
Yes, Mr. Bharat.
No. Right, these are lordships. Now, my lord, what my London friend has argued, he has argued the same thing before the division bench. I did not find anything new. Now, my lord,
you were there for division bench also?
No, my lord, I was not there. But then that is what, my lord, my London friend has only taken a lordship to the particular paragraphs of these cases. I would take lordships something beyond those. My lord, before that, my lord, I will just, that is required on my part, my lord. Lordship will find that these matters, all these matters were kept pending because of the
Region bench judgment.
My lord, Lordship may kindly come, my lord, order dated 9/12/2020, wherein a submission, joint submission has been made by the parties herein that a similar matter is pending before the division bench. Now, my lord, how can there be a division now? Deviation now. Come, my lord, order dated 9/12/2020.
Yes.
London Council for the parties submit that similar matters is pending for the adjudication before the division bench, namely criminal pin number so and so in case of Kamarchand Singh versus State of others, to make a joint prayer that this matter having similar issues to avoid outcome of the same matter pending before the division bench parties.
Okay.
Now, my lord, he has taken a total somersault, my lord now saying something else.
No, he can take somersault after the judgment has come out.
But then this, my lord, it is not my statement which should bind him. My lord, his statement should bind him, my lord. This is a statement before the court, my lord.
No,
my lord, at least that time my lord, my understanding is that, my lord, if I make a statement before a court, and if it is not dependent on a particular situation, my lord, then this statement cannot be varied.
Okay, let's come to judgment.
We are coming to judgment, my lord. My lord, here, my lord, issue is not the issuance of various notifications, my lord. Issue is with regard to the paragraph 4 and paragraph 5 of the 6th schedule, my lord.
Yes.
Whether, my lord, the district council will have exclusive jurisdiction or not. It is not a case, my lord, whether district council has a jurisdiction or not. Now, my lord, now so far as paragraph 4 is concerned, my lord,
yes,
there is no dispute with regard to the fact that for my lord, offences involving punishment up to 5 years, my lord.
Yes.
Oh, below 5 years, my lord. Just let me correct myself. One second. Yeah, not getting constitution.
Do you have a constitution with you?
No.
Yes.
Not. Administration of justice in autonomous districts, paragraph 4. Autonomous districts and autonomous regions. The regional council for an autonomous region in respect of areas within such region, and district council for the autonomous district in respect of areas within the district other than those which are under the authority of regional council, if any, within the districts may constitute village courts or courts for the trial of suits and cases between the parties, all of whom belong to scheduled tribes within such areas, other than suits and cases to which the provision of subpara 5(1) of paragraph 5 of this schedule apply. My lord, this is what is to be taken note of, my lord. Then the trial of suits and cases, my lord, other than the suits and cases falling under subpara 1 of paragraph 5 of the schedule apply to the exclusion of any other court in the state, my lord.
Yes.
And it may appoint suitable person to be member of the such village council or presiding officer of such courts, and may also appoint such officers as may be necessary for the administration of the laws made under paragraph 3 of this schedule, my lord. Now, my lord, what I was trying to point out, my lord, that paragraph 4, my lord, the conformity of power is to the exclusion of the all other courts.
Of?
All other courts, my lord.
Yes. That is your...
My lord, any other court. It says the specific list is any other court, may not be all other, it's exclusion of any other court. Same thing, my lord, meaning is same. Now, my lord, meaning thereby that the cases which fall under paragraph 5(1) would not, my lord, not be governed by the same proposition of law which has been enumerated in paragraph 4, my lord. Now, paragraph 5(1)
because it's out of the exception.
My lord.
Yes.
Now that is where, my lord, this entire Kamarchand Singh judgment is about that. My lord, it is not that the proposition of law which has been dealt with, my lord, it varies from district to district wise. My understanding to the judgment is that, my lord, an honorable division bench said that when a matter is tried by a case who doesn't lack in, my lord, who has no lacking of, my lord, inherent jurisdiction, my lord, or my lord,
on being conferred with powers under 5.1.
My lord, just trying to, my lord, find out the correct word, my lord, which, my lord, until and unless there is a lacking of jurisdiction, my lord, my lord, this is basically a parallel exercise of power. That is what, my lord, the division bench said. Now, my lord, for appreciating that, my lord, but before I come to that, my lord, let us see, my lord, what is the case of the petitioner. Just for a moment, what she will come to their writ petition.
Before the division?
No, writ petition before this court.
It's a transfer petition.
Criminal transfer petition number 2 of 2019. Yeah. And see, my lord, what is their ground, what is their, what they say. Their entire case is based on paragraph 4, my lord. And there is no single averment with regard to paragraph 5.1. Now, my lord, the offence alleged, so far as this case is concerned, is, my lord, is offence falling under section 376 IPC, where minimum punishment is 7 years. So it doesn't fall under the category of paragraph 4, my lord. That is what is to be taken note of. Now, lordship will find paragraph 9 onwards on the writ petition, my lord. This is their ground.
Yes.
Lordship may kindly say so, paragraph 8, my lord. I'm sorry, it starts from paragraph 8. That it is humbly submits that though the present status of the case had reached the examination of the at least 11 witnesses of 15 witnesses projected by the prosecution, it is undisputed fact that in view of para 4 reduced para 5 of the 6th schedule to the Constitution of India, the present trial court did not have the jurisdiction over the subject matter, owing to the undisputed fact that both of the victims and the present petitioner accused are belonging to the Khasi schedule tribe and coming from the same areas of district. That is the Khasi Hills district, which is under the Khasi Hills Autonomous District Council. Now, this is what they say, that the other court does not have the jurisdiction. That is what they want to say, my lord, here. Now, my lord, then further, paragraph 9 of the my lord, he says that the law on the trial of the cases between scheduled tribe within the same areas of district council is no longer res integra. The learned division bench of the Honorable Guwahati High Court, as well as this Honorable Court, in number of cases, had rendered the judgments that the village court, that is the district council court, constituted under para 4 of the 6th schedule of the Constitution of the India is. Now, my lord, here only paragraph 4, my lord, is relative. Now, his reference to the Guwahati High Court cases are, my lord, on the basis of paragraph 4. Now, that, my lord, paragraph 4, we are not on paragraph 4, my lord. Including section 376 IPC, provided both the accused and the victim belonging to the scheduled tribe of the same areas of the district council, and conferment of the power is invested wherein the governor is of the by the governor if the offence is under the India Penal Code or any other law is punishable not less than 5 years above imprisonment. Now, my lord, they basically has taken this case to be a case where punishment would be 5 years in less matter. So they basically, my lord, this their instruction construction made in the writ petition is not tenable. Now, my lord, since my lord, there are series of cases, my lord,
1 second. See, conferment of power is for not less than 5 years. That is what is the conferment of power under para 4.
My lord, is less than 5 years.
No, not less than 5 years.
Well, yes, yeah, under paragraph 5.1. Yes,
not less than 5 years.
Not
see, you see, even like the earlier notification with regard to like personal designator, like on the Judges Council Code also. The thing is that conferment of powers that for offences, transportation of life, blah blah blah, and not less than 5 years. Yeah, that is
exactly my lord. My lord, subsequently,
just now you're submitting. You said that in para 8, what does he say? Para 9. I could not get it.
Para 9 of their
transfer petition. The transfer petition, not writ petition.
Well, I'm sorry.
Yes.
I may be. But paragraph 9.
Yes.
I just read it.
Just read it again. Sunu,
That the law on the trial of the cases between the scheduled tribe in the same areas of the district council is no longer res integra.
Yes.
The learned division bench of the erstwhile Honorable Guwahati High Court, as well as this Honorable Court, in number of cases had rendered the judgments that the village court, that is the district council court, constituted under para 4 of the 6th schedule of the Constitution of India, is the only competent court to try offences including section 376 IPC. That is where I have gone wrong. They could not have. 376 minimum punishment is 7 years. The incident occurred in 2016, my lord. And that the subsequent my lord, CRP was amended later and it has been made minimum 10 years. But then it was 7 years as on the time when this.
No, the conformance of offences punishable with death, transportation for life prison or for a term not less than 5 years. That means 5 years and above.
Oh, yes, my lord.
Not 5 years and below.
My lord, my lord. Exactly, my lord. That, because my lord, paragraph 4, my lord, stands clear by Melvin's judgment, my lord, which my lord on other day, my lord, senior counsel Mr. K.S. Kinjing was relying upon, my lord.
Which judgment?
My lord, that has been appended with their petition, I think, my lord. That is 2023 SCC page 711.
Oh yes, okay. That
my lord, that is Melvin Solankpia.
Yes, Solankpia judgment.
Yes.
Excuse me.
Now, my lord, my learned friend has not relied on anything on this, my lord. Now, my lord, that was the proposition of law laid down therein had been relied on that other time, my lord. The C.K.S. Kenjing, my lord, senior counsel, appearing on that day, my lord. Now, this judgment also clearly makes a distinction between paragraph 4 and paragraph 5. Now, my lord, I will take your lordship to those relevant parts, my lord. But then,
how does Solankpia judgment?
My lord, yes.
Which judgment are you reading first? This commercial?
I will be reading, taking your lordship to commercial, and I will be making, my lord, I will be requesting this court, my lord, to go through the initial paragraphs and read, my lord, paragraph up till paragraph 38 and stretch, my lord.
But first, where we are starting from, only that will be clear. So the logical progression will become there. That we can also, apply the law.
My lord, I'm a bit haphazard, my lord.
Today,
in fact, my lord, I was not very sure that that these cases are there today, my lord. After I arrived in the office and I was told, so I just.
But they will have it tomorrow. Just construct.
My lord, this will definitely, my lord, help me, my lord.
Yes, at least construct your logical progression.
My lord.
Yes.
My lord, only thing is that, in short, my lord, I will just to say.
I understand what is the outlines of your, outline of your arguments with regard to, that now they are arguing that the applicability of this division bench judgment is restricted only to that, where specifically by person powers been conferred upon the sessions judge in reboy in a particular case. And since the notification, general notification that follows later on also says only reboy or naval officer, even then they have not changed the position. Like with other districts, it will remain, it's a para 4 and only reboy maybe, that it applies there. That is Mr. Chandra's judgment in some substance. But then what you have to seek to, put forward is that, look, that is irrespective of that notification, or that the notification has no role to play at all in the present scheme of administrative justice, because we have to look at para 5.
That is what, my lord. Looking at the notification,
parallel jurisdiction, and para 4 stands a different footing. Para 5 is a different footing.
That is
so at least, you construct your arguments we will hear. Tomorrow or day after?
Any day, lordship is convenient.
We'll have a day after then. We don't express a difficulty with
tomorrow, you lordship.
Tomorrow, yes. This is matter for the hearing tomorrow.
Tomorrow, lordship. Because day after, you have to be out.
You're going fishing.
Enjoy.
Yes. Just matter for you tomorrow. Only that, yes. Only because the point should not be stretched too far.
Well, see, the reference to this notifications will definitely confuse us.
Of course.
So that is what, my lord.
Of course.
I'm trying to avoid it, my lord.
We understand that. We understand that because what is Mr. Chandra trying to project, we understand also.
Yes.
That if it's specifically been made Then why notification for other districts?
Therefore, I'm not referring the background of the other notifications.
No, I understand where he's getting.
My lord, he cannot raise this argument right at this in view of these submissions recorded earlier.
I'll clarify it.
That is also, my lord. That is also, my lord. If required, my lord, he can place some decisions on that. But then it will reflect badly on lawyers, so I do not want to do that.
Rather than reflect, better deflect. From my yes.
Second call. Second call, attempt 33.
May I please, Your Lordship? Your Lordship, Mr. SD is still on next courtroom 3.
Because some also they're fighting each other there only.
Yes, Your Lordship. Item number 12.
Okay, as the party submitted the matter listed after 1 week due to the absence of the arguing counsels.
37.
According to MS please that matter be 1 week due to the absence of the arguing counsels. Yes. Yes.
37. He's still next in the courtroom 3, Your Lordship.
Doesn't matter. We can't pass of time being anymore because you've adjourned all the matters today also. You can start.
Depends in the
Some urgency is there. You don't have no idea. It's only 12 o'clock. Where's Mr. Paul? Just call him. Any private respondent?
Yes, Lordship.
Are they there? Who's the private respondent?
D. Mouthall.
Mouthall?
Apologies,
No problem. Those matters pass for time being because they said that Mr. D was on legs.
Limited issue, there's a challenge, to settlement of a fishery without a tender.
Yes.
It is our case, that we had filed an RTI, the district council has said that they've settled the fishery without any tender. They say, that was done because of the COVID protocols. That's all. It is an admitted position, that there's no tender. The counter affidavit, I can just take a very quickly,
Mr. D is coming.
still going on, Your Lordship, the hearing. Item 12.
That's the only thing. Okay, day after tomorrow. Here's limited issue. You prepare the matter, okay? If Mr. D is not here, I expect you to argue the matter. Okay,
1 week, Your Lordship. 1 week, Your Lordship.
Why want you to prepare the matter?
May I please, Your Lordship? Lordship, I would like to mention one matter, my lord, for listing tomorrow, my lord.
Not now.
Yes, my lord, I'm sorry, my lord, I could not reach time.
Should have mentioned it earlier. We don't want to set precedents and stuff like that. Then everyone will start mentioning after the matter, before the courts run. What's the matter about?
It's regarding the selection process held in Nehu for the post of professor in Zoology Department, my lord. The selection, Zoology Department. The selection process is, my lord, there are some discrepancies in the selection process.
In which way?
My lord, the candidates which are called for the interview, they were not possessing all the requisite criteria, my lord, as per the advertisement.
So how do you know that?
My lord,
But if they don't possess the criteria, they'll be rejected.
my lord, they are not been they could not call them for interview, my lord, because they do not possess all the requisite.
And you possess all the qualifications.
My lord.
Then when is the selection to
My
be
lord,
held?
it is on 26th or 27th, I'm not sure, my lord. So, my lord, there is some urgency, my lord. For listing tomorrow, my lord.
Motion?
Motion, my lord.
Okay, but this is disappointing.
Who can you go for?